Hello, this is Joseph Patell of the Patell Law Group, and in this video we will be going over contingency fee agreements. Contingency fee agreements are primarily for personal injury cases, and that's pretty much car accidents, slip and fall, dog bites, things of that nature. Generally, we do not offer contingency fee agreements for most other lawsuits, only those where we'll be dealing with in fact, an insurance company on the other side. So let's go over these contingency fee agreements or personal injury agreements. Essentially, these are when you hear lawyers on TV stating that we don't get paid unless we get money for you. That's essentially what this type of fee agreement is. So let's just go over some of the finer details so you actually understand exactly what you're signing and how this retainer agreement works. So in the first section will just be your personal information, the law firm's personal information, and the subject matter that is listed right here. This particular one was a personal injury slip and fall case. I'm just trying to make this as simple as possible, so we use one of the more simpler. It could be more in-depth. It could be an automobile accident on date listed at the intersection of XYZ. This is just made for example purposes. The subject matter might be more detailed in your particular contingency fee agreement. So that's what the subject matter would be, meaning that if there's anything that comes out of representation pertaining to your case, that we don't in fact do that. So one of the things is dealing with insurance companies so you can get a rental car. Not part of what we do. We may negotiate that in the settlement at the end, but we don't actually attempt to deal with your insurance company pertaining to rental cars. That's just a for instance. We're primarily focused in on getting you money back for your injuries, and in some situations we may in fact help with the monetary damages per the car, but that's not in fact part of the agreement. If it does not mention dealing with getting your car replaced, that's not the personal injury is how you were hurt and getting money for that. It is not about getting money for your car or other property damage, just to make that clear. The compensation, the most important part of this is that prior to litigation, meaning prior to us having to file a lawsuit on your behalf, meaning that there was no settlement reached before we reached a lawsuit, or the insurance company has not reached settlement with us and your statute of limitations is about to run and we have to file a lawsuit to protect your case. Anything before a lawsuit being filed is going to be 1/3 or 33.33%. Now, if litigation is initiated in any state, superior or federal court, that number jumps up to 40% instead of 33.3%. Also in here, sometimes judges awarded attorney's fees. That will be addressed in here. And there are a number of other situations that, as always, you should fully and completely read all retainer agreements and all contracts for that matter. This is no difference, and in this situation you should definitely read your whole contract, and if you do not understand any part of it, please speak to the lawyer that has signed the retainer agreement. Do not speak to any of our staff members, as the only person who has the ability and ethical responsibility to in fact answer your questions is the lawyer who signed your retainer agreement. Okay, moving forward. Payment of costs and expenses. This is important for you to understand and will be forced for you to actually initial these sections. So go through them fully. Essentially, we will be paying the costs associated with your case. And if we win, we get what is critical is we always get our percentage, which is listed right there, and then we get paid 100% everything it cost us to handle your case. That is for getting medical records, for hiring experts, shipping and handling, If we need third-party reports that review medical records that will be submitted at trial or used to obtain a settlement for you. Literally any amount spent on handling your case will be paid out of your portion of the settlement. This is extremely important. A lot of clients want to go full blast. They want everything. They want to go to trial. They want expert witnesses. You just need to understand, going to trial, the more money is spent on your case, the less money you will receive in your settlement, because all of those expenses that are incurred by the law firm will in fact be paid out of your percentage of the settlement and are not in any way covered by the attorney's compensation. So the law firm attorney get their percentage, and then prior to getting your percentage, all costs are deducted from your percentage. This is important because as you're considering should you settle the case, you should always be thinking, how much is this going to cost me if we go all the way to the end of a trial? These are subjects that are certainly important for you to be discussing with your attorney that's handling this matter. So if this section here, client responsibilities upon termination of service, this goes over what will happen and how termination of service could be initiated. Since there are no agreements, there's no payments on a contingency fee agreement, that does not pertain. But one of the reasons that an attorney may in fact terminate representation is if we find out the client has in fact lied to us. If the client has misrepresented material facts, then essentially you've lied to us and we've moved forward on a particular case on erroneous or in fact lies. So in that particular situation where a client has in fact lied to the law firm, you certainly want to read these sections fully to understand what your responsibilities are and what the law firm will in fact do. This next section has to do with prior counsel. Essentially, you're going to be initializing this, either stating that there was no prior counsel, or if there were, you're giving us all of the signed retainer agreements, any fees, bills, any type of consideration or payments that that law firm or attorney are expecting. We need to see those before we do any work. Some clients like to start with one attorney and then after the first settlement discussions are had, they think that their case is worth significantly more and jump from one attorney to another. You got to understand that once any settlement amount is presented, then that percentage fee is considered due to the firm. So essentially, if you moved from one attorney and came to the Patell Law Group, and that attorney has fees, that money that that firm has put into it, or if they've reached some sort of settlement, even if it's not one you accepted, if they did in fact receive a bona fide settlement offer from the insurance company, well, then that lawyer is actually due their contingency fee pertaining to that amount, even if you didn't sign it and you move to another attorney. That previous attorney is going to get paid. So we need to know that, and this section will deal with the fact if you do not tell us if that in fact the law firm does get a percentage, we'll still get our percentage. So this is very critical. If you did have a previous attorney, you must disclose that and must give all pertinent documents that are enumerated in this section to the law firm before any work has begun. You may be paying two law firms on one single case, which will dramatically eat up your percentage. You do not want to get into that situation, or at least you want to know what the ramifications are at that point. The next pertains to termination of the law firm by the client and what the fees for any work that were actually performed. The next section goes to attorney's fees and compensation for case resolution. Essentially, when law firms work on personal injury cases and we have filed a case in suit and we have certain billable times or expenses that are due on the case, or if we were to reach some type of settlement offer, most law firms will in fact place a lien on that particular case so they can get paid when that case is in fact settled. This section pertains to fee disputes. Essentially, if there are any fee disputes, the parties, the client and law firm, agree to try to resolve these amicably, and if not possible, then this matter will be sent to the Fee Arbitration Board of the Massachusetts Bar Association. So, in personal injury cases, sometimes when you file a lawsuit against someone, they in fact file counterclaims against you stating that you in fact injured them and that you will in fact be being sued during the personal injury, automobile accident. Usually automobile accident is where you'll get counterclaims in personal injury cases, but they may happen from slip and falls, or they could happen from dog bite cases. Extraordinarily, it does in fact occur sometimes. This section is very important. As your law firm, because we're handling your personal injury case, we are under no obligation to defend you whatsoever. By hiring personal injury attorney, you're hiring us to go get money for you. And in no situation are we going to defend against counterclaims against you. That in fact is the responsibility of your insurance company. In most cases, we're talking about an automobile insurance policy. They would be in fact responsible for providing any defense that's needed. If you do not have insurance, let's say it's a slip and fall or a dog bite case, even if you don't have insurance, that's going to cover it. If you wanted us to cover any counterclaims or claims against you, you would in fact have to sign a separate and individual retainer agreement on an hourly fee basis for us to perform that work. It's just critical to understand that we're here to get money for you. We are not here to defend you against any claims that might be placed against you. That in fact is either the insurance company that you have a policy with, it's their responsibility, or it's financially your responsibility. In some cases, the judge will in fact award attorney's fees, or in some settlements there are attorney's fees. This section here goes into detail about that and how that is applied to any fees that are incurred by the law firm and due to the law firm. This next section, 14, is complete understanding of the agreement. Essentially, everything pertaining to this agreement is in this agreement. What this means is if you misunderstood anything verbal, or something was said, or you heard something outside the context in person in verbal discussions and is not enumerated in this contract, it does not pertain. Regardless of what has been said, everything of this contract is in the contract. And if anything is not in this contract and it was stated, this must be in writing and signed by all parties, or it is in no way part of this contract. And also the final piece is essentially, by signing this contract, you have agreed that you read and understand all parts of said contract and are contractually obliged to follow the different sections of this, in fact, contract between you and your personal injury attorney. So, if you have any questions whatsoever pertaining to your personal injury fee agreement, please contact the attorney who has signed it at the bottom. There are many different lawyers at our firm, so depending who signed your agreement is the attorney, due to their ethical responsibility, and they're contractually obligated to attorney-client retainer agreement for personal injury service, you must speak directly to them. Please do not speak to receptionists, legal aides, or paralegals pertaining to something such as this, a contract fee agreement that an attorney has signed. Please only discuss the matter with the attorney that signed it. This is Attorney Joseph Patell, and today we have discussed contingency fee agreements. Thank you and have a good day.
If you enjoyed this video, please press the like button and subscribe to our channel. Also, click the notification bell to get future videos that we'll be putting out. And please share our content on social media.